Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we are going to talk about two different but somewhat related subjects, being a personal representative and also being a conservator or guardian. Let's head on down to the beach and talk about that. So the reason we're doing this video is because of a video that someone linked for me that showed the deposition of one of the people who was deposed in one of the Murdaugh cases. This is the Satterfield case, where the Satterfield heirs are being represented against a number of entities, including the bank that was party to a lot of this fraud. And the deposition was taken after the bank was out of the case and after the individual being deposed was out of the case. So from that, I think it's fair to say that he had less of an incentive to lie or conceal or cover anything up. And it's really interesting for the testimony that it gives. Now, what is a personal representative? A personal representative is someone who is appointed to represent the estate of a dead person. And whether it's called administrator, administratrix, testatrix, whatever nomenclature a court gives it, it is a person whose sole job is to gather up all of the dead person's assets, put them in a little bucket, and then distribute them to the people who have a claim on them. And that would include both creditors and heirs. And when you're talking about a conservatorship, what you're talking about is someone who is either incompetent to manage money because of infirmity, maybe they have Alzheimer's disease or some other kind of dementia, or they are too young. They are below the age of majority. They can't sign a legal contract, and for that reason, they need somebody to look out after their financial interests. Either way, it is an important job with important duties, which we'll get to in a minute. But first, let's look at this segment of the deposition where the attorney asks this gentleman what kind of preparation he went through to become a personal representative.
How many times did you meet with Tony Satterfield or Brian Harriet?
I didn't.
How many times did you ever speak to Tony or Brian?
I didn't.
How many documents did you send to Tony and Brian in connection with the work that you did as personal representative of the estate of Gloria Satterfield?
None.
Did you speak with any of the family members of Gloria Satterfield during your representation of the estate as the PR?
No, sir.
Okay. And my understanding is you were personal representative from about December 18th, 2018 until late September of 2021. Is that correct?
That is correct.
All right. Other than your initial documents that you filed with the probate court, and then the documents that Tommy helped you file in, I think, October or September of 2021, did you file any other documents with the probate court?
No, sir.
Okay. My understanding in this matter is that this was the first time you acted as personal representative of somebody's estate. Is that correct?
Yes, sir.
Okay. What did you do to educate yourself or avail yourself of what your responsibilities and duties were?
Spoke to Corey Fleming, the attorney for the estate, when I met with him.
Okay.
Asked him what I needed to do as the personal representative.
Did he give you any written documents or a list of items that you were supposed to do?
No, sir.
Did you do any independent research on your own and look up under South Carolina law what a PR is supposed to do on behalf of an estate?
No, sir.
All right. Did you talk with Alex Murdaugh at all about what your duties would be as personal representative?
I had questions when he asked me if I would serve.
Okay. Did the request come from Corey or from Alex for you to serve?
Alex.
Okay. And I know that there's a document that we'll get to where you said that you sought permission from your supervisors, whether it was Russ Lafitte or somebody else on the board. Did they give you the consent to serve as PR?
Yes, sir.
Well, that's pretty shocking, isn't it? You know, you can you imagine somebody coming in and saying, "Hey, you know, you want to be an astronaut?" And saying, "Well, yeah, I'd love to be an astronaut. What do I need to do?" "Ah, don't worry about it. We'll put you in a space capsule, shoot you up to the moon, and everything will be fine." Well, that's pretty much exactly what happened to this poor gentleman, Chad Westendorf, I think his name is. Chad was asked by Alec Murdaugh, somebody that he said he had gone to school with, who was sort of a friend, but not a close friend, just somebody he went to school with, knew his reputation, knew he was a lawyer, knew he was a good guy. And so he asked him to be personal representative, and he said, sure. But then he made a terrible mistake. He didn't inform himself of what the duties for that job were. Now, even if you have a lawyer, it is a really good idea if you sign up to be either a guardian, a conservator, or, in this case, a personal representative, that you find out independently what your duties are, because this gentleman never did that. Now, why is that important? That's important for a couple of reasons. One of them is that as a personal representative, you owe the estate a fiduciary duty. What is a fiduciary duty? Fiduciary duty is sometimes referred to as the duty of an honor most sensitive, meaning that you have to place the heirs and the estate and all of the creditors of the estate above yourself. You have to put them first. Everything you do is done to serve them and not to serve you. It's one of the reasons why we have an obligation as personal representatives not to self-deal. So, for example, somebody asks you to be personal representative for Mrs. Jones, and you gather up all of her stuff, and you realize she's got this really sweet 1968 Mustang that is in mint condition, that she only drove to church on Sundays, and it hasn't really been driven in a couple of years, got a dead battery and all that. Well, that car is it's probably the most worthwhile asset in her estate. But you have to sell it, so you sell it to yourself for $5,000. Well, that is self-dealing, because the value of that property is worth a lot more than that. And if you're caught doing that self-dealing, there's going to be a lawsuit. You're going to be held to be liable for that breach of your fiduciary duty. Now, the heirs may never find out about it, particularly if they're in a different state. They may just wait for you to send them a check. But the creditors are probably very likely to find out about it, particularly if you have a hospital or a doctor or some other entity who invested hours and hours of time and lots of money in trying to make this person well, and they died anyway. The last expenses, the final expenses, the last hospitalization, the payment to the mortician and the funeral home, all of those have to come from the estate. And when they come out of the estate, the net effect of that is that those creditors get to come before the heirs, because those are obligations incurred by the decedent. And because they were incurred by the decedent is responsible for them. So any money that's left in the estate after that belongs to the heirs and is basically distributed according to either the will, which is what happens when you have a will and why you should have a will, or it gets divided by virtue of the laws of intestate succession, which is essentially the state where you live making a will for you. And whether or not that will actually conforms to your wishes is, well, it's just probably not true, because a lot of us would like to see that our assets go to other people, not necessarily the people the state thinks they should go to. So, because you have these duties to creditors and to others, people are going to be looking over your shoulder. They're going to be looking at what happens. And of course, you have to file reports with the judge, and you have to do you have to do two things. First thing you have to do is an inventory. This is all the property. These are the potential causes of action that the decedent had. A lot of times, a personal representative gets appointed because someone's killed in a car wreck and they need someone to prosecute the survival claim. See, there are two claims when someone is killed wrongfully in many states. One of them is a survival action for the pain and suffering before death, and the other is a wrongful death claim, which basically inures to the benefit of the heirs. But if you're going to prosecute the survival claim, you need a personal representative because the personal representative owns that particular claim. So you get a personal representative appointed for that reason. And otherwise, the personal representative is basically appointed to pay out all of the claims that other people have. Now, generally speaking, creditors only have, I believe in most states, it's about 1 year to bring any claim against the estate. And if they don't bring that claim within the year, then any claim is barred, which is one reason why in a lot of cases, it may take more than a year to get an estate closed, because the personal representative may want to wait till that year is up before he pays out anything to the heirs. And if he doesn't wait for that length of time, then in many cases what happens is somebody comes in at the 11th hour with a large claim, and now it comes out of the personal representative's hide. Now, he can make requests that the heirs disgorge some of the money that they were given, but there's probably not going to be a requirement that they do that. That is one of the reasons why personal representatives in most states have to have a bond. What is a bond? A bond is a surety relationship. That's where the personal representative goes to an insurance company, usually, and says, I need you to issue me a bond so that if I am found to be liable to the estate for anything, the estate will be protected by that bond. And you'll pay a premium, usually, something in the area from $500 to $1,000 for that bond. Normally, that is an estate expense. It's picked up by the estate. But either way, you basically have this bond that protects the estate. But it does not protect you as the personal representative. That's because if they issue the bond as your surety, the suretyship agreement will always say that you have to make the insurance company whole afterwards. So the bond is for the protection of the heirs and the creditors. It's not for your protection, which is why you have to know what you have to do. And it only makes sense that if you don't know what you have to do, it's very easy to make a mistake. Now, in most cases, you have a probate lawyer who is helping you through that process, and that probate lawyer knows what he's doing. But if it is a personal injury lawyer and not a probate lawyer, he or she may not know all of the things that need to be done to handle that probate estate, which is why in most cases, good law firms hire that out to somebody who does know how to do probate law and let them handle that for the purpose of establishing and operating the estate and closing it at the end of the case. So that's what goes into being a personal representative. Conservatorship is a little different than that. Many times, several years ago, we had a situation where a mother of 3 children was the victim of a bad pain pump. The pain pump had a defect in its design, and it gave her a large bolus of Demerol, and she died of an opiate overdose. And so we went to sue the maker of that pump. Now, when we did that, we had kids who were from, I think, 9 through 13 who could not legally sign a contract, which meant we had to get a conservator for them. And in that particular case, what we always do is we use a bank. Banks have trust departments, and so we would get the trust department at XYZ Bank to come in and be the conservator. In that case, mom was divorced, and the father of the children was, shall we say, not possessed of a good reputation. He had a little bit of a problem with alcohol, and potentially with drugs. And we did not want to see the children's money squandered on those things. So we went out and got a bank to serve as the conservator. And the reason we did that is because, as is always the case, you have to protect the client from bad things that are predictable and preventable. And both of those things were predictable and preventable. So we got the conservatorship. In most cases, when you get a bank to do that from someone in the trust department, they understand what a conservatorship is and what a conservator does. He manages the funds on behalf of the children and uses it for their use and benefit. And that's what happened in that case. The funds were deposited, and when the children came to legal age, they would get some portion of that amount of money. Again, that's done to protect them. In this particular case, in the Murdaugh case, what was done not to protect them, but to exploit them. And as you watch this deposition, and you can find this deposition out there on YouTube, when you watch this deposition, what you realize is that this gentleman feels very badly about what happened and did not understand what was being told to him by the lawyers, and he did not understand the accounting, but he went along with it anyway because they were lawyers. You know, President Reagan was, I think, one of our greatest presidents, and one of the things that he said was trust but verify. There is no clearer reason to trust but verify than the clip from the deposition here. You had somebody who was appointed to a position who did not understand the responsibilities, who did not understand what was required of him, and who, for the most part, simply did not get what he was supposed to do. And as a result of that, those individuals were harmed, and then there was additional litigation that had to be brought in order to make them whole. So, just to recap, the duties to the estate are to make a complete inventory of the assets, to gather all of the bank accounts and personal property, and that doesn't include items that are disposed of by pay on death or transfer on death. A lot of car titles are transferred on death. But gathering up all of that information, all of that data, all of that personal property into one bucket, that is a must. Then they collect the claims from the creditors, and they protect the creditors' rights by keeping the funds in the inventory safe until it's time to dispose them. It's because they have to put those creditors first. They have a duty to the court, which is to create an accurate accounting, which means at the end of the probate proceeding, at the end of that, they have to account for every dime that came into the estate and every dime that went out of the estate. It has to jive with the inventory, and it has to be according to all of the court's orders and completely honest. And again, in a conservatorship, it's appointed because of age or infirmity. Somebody who's a minor, somebody, for example, who's not a minor but who's brain injured and unable to manage their own assets, someone who has Alzheimer's disease, you become a steward for that person's incompetent assets. In most cases, it requires a bond. And if you breach the fiduciary duty, the bond pays if you cannot, but you're on the hook for the surety. And you have this fiduciary duty. You have to place the estate and ward's interest above your own. You can't involve yourself in any self-dealing, and you cannot favor one heir or interest over another. You have to favor the creditors over the heirs. But if you like Johnny better than Susie, you can't give Johnny more because his rights are going to be determined by the will or by the laws of intestate succession. The personal representative does not have a right to make a determination in most cases as to the disposition of assets. And of course, you also have a duty of honor in that case, and that's where the fiduciary duty comes from. So that's what I have for you today. If you have any questions, please leave them in the comments down below. Like, share, subscribe. You know all the things I ask you to do. And if you have the opportunity today, do something nice for somebody. Be kind. Go out of your way to open a door or to say something nice about something that you noticed about someone else. I like your car. I like the way you keep your car clean. Something minor. Just do something nice for somebody else. It'll make your day. Have a terrific day, folks, and I'll catch you on here next time down at the beach. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.